Hello, mates. Just a quick note to let all of you know how much we at the Scandal Sheet podcast appreciate our loyal audience. We hope our show takes the edge off your work or school commute, your time in the gym, the household chores, the dog walk where you have to pick up yucky poop, or anything else. If you do appreciate our work, we'd love it if you could help us support the pod by becoming a member of our pod on Patreon. Your membership gives you access to exclusive content, like uncut and alternate versions of episodes, bonus episodes, and transcripts. We will also answer your questions on air in an upcoming episode, all for only the cost of a single cup of Starbucks coffee per month. All you have to do is to go to patreon.com/scandalsheet. That's patreon.com/scandalsheet. We're going to continue to do everything we can to simultaneously entertain and inform you with our shows. But we'd appreciate if you could show us a little love back. Cheers, everyone.
Disclaimer: no Supreme Court justice was harmed during the production of this podcast episode.
July 10, 2024, Congresswoman Alexandria Ocasio-Cortez speaks on the floor of the House of Representatives, courtesy C-SPAN.
I rise today to introduce articles of impeachment against Associate Justices of the Supreme Court Clarence Thomas and Samuel Anthony Alito, Jr. Mr. Speaker, nomination and appointment to the Supreme Court is one of the highest privileges and most consequential responsibilities of our nation. Such an appointment is uniquely insulated in its power. Confirmation to the court is a lifetime appointment whereby justices are entrusted with decisions that powerfully shape the nation as well as the lives of every American. For this reason and others, the Constitution rightfully and explicitly holds justices to even higher standards than members of Congress or even the President. And Congress has exercised its power to reinforce this higher standard of the judiciary before. This body has impeached and removed 8 federal judges. These judicial standards require justices to recuse themselves in any proceeding where their impartiality might reasonably be questioned. The justice must recuse. They are required to recuse. That stringent and sacred standard exists for the good of the ruling, the judiciary, and the country.
True crime.
Sex.
Political conspiracy.
Celebrity gossip.
Murder.
UFOs.
Crooked officials.
The occult. Assassination.
Courtroom drama. Rape.
Corporate scams. Scandal Sheets. Hello, everyone, and welcome to Scandal Sheet. My name is Thad Helsley, and I am joined, as always, by my co-host, Anya Rada. Anya Rada, how are you enjoying your summer on the surface of the sun?
It's hot as balls, Thad. It's hot as balls. It's too hot. I can't go anywhere.
Yeah, I know. And I'm very excited today because this is our 3rd annual Supreme Court review for the 2023-24 term. Of course, just about every case that goes into or comes out of First Street Northeast is a scandal in some way. And to help us out, we are pleased to welcome back a frequent guest of this pod, New York City's 4-year multi-lawyer, super lawyer, David Grover from the firm of Grover and Fencerstock. Welcome back to the pod, David.
Guys, so happy to be here. And I got to tell you, Scandal Sheet podcast could not be more apropos in these very strange times we are living in right now, don't you think? You could do an episode a day these days if you had the time to do it.
Right. Well, you know, I just wanted to ask you, and also our listeners are curious. I mean, you've been named a New York super lawyer 4 consecutive years. I mean, you're like the Tom Brady of lawyers. That must be some kind of record, huh?
Well, I mean, there are a few others. I mean, there are great attorneys in New York. We're very proud of our firm, proud of our people, proud of our staff, and love our clients, especially Scandal Sheet listeners when they call us. We're very happy to serve them. So, yeah, I appreciate that. Thank you. And a lot of hard work goes into that. Just like Tom Brady, a lot of hard work goes into that.
Okay. In the past 2 years that you've helped us with this review, our listeners have always said to me, they've said, well, Thad, you're a shrill and horribly biased boob. And then they appreciate, though, that you are a very fair and balanced person. So what do you think about that? Boob versus fair and balanced.
I wouldn't call you a boob. I'd call you emotional. Excited.
Okay.
You do care about the issue, so I wouldn't say that anything bad about that. And from my end, it's just more from my background, my profession. When you go to law school, I don't know if I mentioned this in prior podcasts, what you do is you read cases. You read the opinion, and when you first read it, you say, that makes a lot of sense. I get it. And then you read the dissent, and you say, that makes sense too. So I guess the point is most court decisions, most issues have two sides that make some sense. There's some basis for it. So I think if you read both sides, you can see what you may not agree with one side or the other, but you kind of can see where they're coming from for the most part.
That's a very lawyer answer.
Yes, it is. Actually.
I like it.
and you need a lawyer there, Andra, don't you?
I do.
But when I'm an advocate for my clients, yes, I can't be that balanced. I have to be a little bit,
an advocate for your people.
I represent my clients to the best of my ability. But yes, if you look at both sides, I think you understand the case better.
Right.
So if Thad was your client, would you call him a boob?
I would not call him a boob.
Not to my face. He would do it at home to his wife, Jill.
No, if he was a defendant in the case and I was the plaintiff's attorney, I might. But that's a different story.
Okay. All right.
Well, there you go.
And of course, no episode would be complete without our artificial intelligence engine, Bernice.
Hello, everyone.
Bernice, I'm just curious. When we first hired you 5 years ago, you and IBM's Watson were really the only AI game in town. Today, the U.S. is so AI crazy, every toaster and electric can opener has an AI engine built in. Do you feel like you've been pushed aside in this crowded space?
You didn't need AI to help you burn a bagel in your toaster. Most things labeled as AI today are no more intelligent than a mentally retarded earthworm with a nasty heroin habit. After this craze wears off, people will go back to making their own bad decisions.
Thank you, Bernice. That was cheerful. Thad and David, since the 2021 term, when we had a 6-3 conservative supermajority in the court, the terms have often been described across the political spectrum by adjectives like historic, momentous, activist, and blockbuster. Are courts supposed to be activist? What's going on?
We are living in, like I said, very interesting times. This has been probably the most important, dramatic court, at least the last couple of terms in really our lifetime. So it is, you can't understate how big these cases have been. And yes, there's a 6-3 conservative majority in the court right now. But think about it for a second. 2 or 3 of those conservative justices are not that radical, for lack of a better term. Roberts, Amy Coney Barrett, even Kavanaugh to some extent are kind of pragmatic, are not looking to do dramatic things, like things done slowly. So imagine if they weren't on the court and there were more radical conservatives on the court. We don't have that. So as much as things have been pretty dramatic or out there, it could have been much worse. So we're kind of, well, maybe worse is the wrong word, depending on your perspective. But it could have been a lot more radical, a lot more dramatic. But those 2 or 3 justices try to rein in the court to at least have some semblance of being pragmatic, not going too far for the public.
Well, the court only decided 62 cases this year, and there were many controversial cases to talk about, actually. But our listeners don't want to be here all week, so we decided to narrow it down to 3 that our friend David chose. Bernice, what is our first case and what is it about?
Case 23-939, Donald Trump versus United States. Former President Donald Trump was indicted in August 2023 on 4 counts arising from Special Counsel Jack Smith's investigation into the January 6, 2021 attacks on the United States Capitol. Trump claimed that he cannot be prosecuted for his official acts as president and that a former president cannot be prosecuted unless he has first been impeached by the House and convicted by the Senate. Question: does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office, and if so, to what extent?
David, you're up. What do you think?
Well, obviously, this is incredibly unprecedented for a number of reasons, one of which a president has never been indicted for a crime before, so this has never been done. And I think it was considered pretty surprising, the decision, at least by most Supreme Court experts. But, and the decision is, if you read the majority opinion, all right, what do they say? They basically say you have to make a distinction between official acts, which the president is allowed to do under the Constitution, and personal and private acts. So they're basically saying you have absolute immunity for anything that's an official act, yet no immunity for anything that's a private act. Now, the dissent came back and said, well, wait a minute, this is kind of crazy because, can you have a political opponent assassinated? Can you take bribes and somehow call an official act? Well, that's where it gets interesting. I think the problem, and we'll see how this plays out down the road, probably the biggest problem with the case is the ambiguity, right? What's an official act? Yeah, yes, you can.
Right.
In the Constitution.
What is an official act?
But, can you kill your political opponent and claim it's an official act under one of those constitutional provisions? Can you take bribes? The answer is probably not. But the case didn't really delve so much into it. So what they came up with in the case is go back to the trial court, have a hearing, and have the judge decide what's an official act, what's a private act. After she makes that decision, guess what happens? It gets appealed. So we're going to be going through this again.
Well, we're just going to come right back to the same place, right? They just do not want to. Let me ask you this, David. So Richard Nixon, he was never convicted of anything, although he resigned of his own voluntary volition because it was very clear. People from the Senate and the House came to him and said, look, you're going to get impeached. Maybe you want to resign and avoid that whole awful thing, which he did, right? But he had no chance to be convicted because his vice president, who had become president when he resigned, Gerald Ford, pardoned him. Now, he hadn't been charged with anything. So it was like, I'm giving you a blanket pardon for any. Oh, did you jaywalk? Did you blow that stoplight? Or did you bug Democratic headquarters? But he was pardoned for everything. But you wouldn't have to pardon a guy who couldn't be charged in the first place, right? So weren't they thinking, okay, if I don't pardon him, the dude's going to jail? Is that true?
Yeah, I think that was the thought process back then. But remember, the difference between that
1974, yeah,
is that Trump has state court cases against him. Those cannot be pardoned by a president.
Okay. Okay.
Yeah. So that's the big issue there. And so we never got this far before. Remember, the pardon is not for things going forward. It's for retroactive. It's for prior acts. So you can't be pardoned for something in the future.
Okay.
So when Ford pardoned Nixon, it wasn't like Nixon could go out tomorrow and murder somebody and get away.
No, it was for the Watergate burglaries and blah, blah, blah.
Yeah,
the cover up and everything. Yeah.
And it was a federal investigation, federal crime at the time. So it had all that weight where they couldn't bring anything in state court. Where a lot of these are state court cases, so even with pardons, it wouldn't make a difference. But in this case, we have the immunity issue, which the immunity issue would actually apply to state cases, potentially.
Well, what is the result of this? What does this mean that Kamala Harris can just walk down the street and shoot somebody?
Well, that's what the dissent basically said. Yeah, that's what they said. If you read the case carefully, you can come to that conclusion. I don't think that would happen. I think if someone did something so egregious, it would be considered not an official act, and they probably would be charged with a crime. But this just makes a lot of strange. It just creates too much room for interpretation, in my opinion. And again, if you read the majority opinion, they say no, no, no. This is just for official acts, and if you do something out of bounds, we will. You can be charged. And who knows? But who's to say what's official, what's not official? So we'll find out after the judge makes her decision shortly, probably within about a month or so. And then when it gets appealed, well, we'll see. Does the Supreme Court agree as to her decision as to what's official, what's not official? It looks like one of them, something to do with the DOJ, might be considered official. The other items, probably not so much. So that's where it gets that's really gets interesting, really into the weeds there, is what does the Supreme Court, well, let's be frank here, what does Roberts and Kavanaugh and Barrett think, actually, because they're really the deciding votes. What do they think are official compared to not official? Amy Coney Barrett she wrote a concurring opinion here that was a little more nuanced. So you would think she might be a little more towards some of these things being not official acts, and maybe just one of them being an official act. So again, this is just the beginning. Thad, you have room for a lot more episodes about this because this isn't going away anytime soon. So,
Anurada, what do you think? I'm sure. I think there's a tenant that you would probably, if you had a loaded pistol, you'd probably point it at her.
I say nothing. I plead the fifth.
Okay,
my lawyer's on this call. I just feel like there's also, it's kind of ridiculous because it's like you can do 200 things, but because things are not completely black and white and there's room for interpretation, what does that mean? You just get away with the 200 things? So it's just, I don't know. It's a little ridiculous. I feel like things need to be spelt out better. Ironed out, if you may.
Yeah, well, that's the fear. There are things in this case, without getting too detailed here about presumptions of being an official act and whether you can use evidence of an official act to prove the crime and the unofficial act. So they threw a lot of monkey wrenches in there that might make some future cases difficult. And, we worry as a country that was established to get away from having a king. I don't think most people want that to happen. So, hopefully the courts lay down some little more detailed rules about how this could be done going forward.
Get your shit together, courts.
Yeah, that's why we're here.
Bernice, what's next?
Case 43 to 411, Murphy vs. Missouri. Multiple plaintiffs claimed that various defendants, including numerous federal agencies and officials, have engaged in censorship, targeting conservative-leaning speech on topics such as the 2020 presidential election, COVID-19 origins, mask and vaccine efficacy, and election integrity. The plaintiffs argue that the defendants used public statements and threats of regulatory action to induce social media platforms to suppress content, thereby violating the plaintiffs' First Amendment rights.
David, another 6-3 decision.
Yeah, this is kind of interesting as well, because it raises an interesting issue, right, in terms of social media, in terms of what can the government, we have a First Amendment right to say whatever we want for the most part, with some exceptions.
Right.
Now, in this case, like we heard, the government was not forcing, but pushing the social media companies to not put things out there that were, in the government's opinion, blatantly false, whether it's masks or vaccinations or other things like that. So now it comes down to the question is, well, all right, First Amendment, but if the government banned it, I think that would be clear. The thing is, the government didn't really ban it. They kind of urged the social media companies.
They pressured them, right? But they didn't really slap any laws on them. They just said, look, dudes, please.
Yeah, so the question it really comes down to is it a violation of the First Amendment if the government urges a social media company not to promote certain things? Or is it not because they didn't force them to do it? So it's an interesting question that we don't have the answer to, because the court didn't answer the question, because the plaintiffs in this case didn't have standing to bring the case.
Was that the only reason?
Yeah.
Just they didn't have standing? Why did they, okay, let me ask you this. Why did they even take the case if they were just going, I mean, because they could have, they receive, you told me in the last podcast, they received like, I don't know, 1,000, 2,000 requests, and they take 60, so why did they even take it? Just to say, I guess just to grandstand and say, guess what? You don't have standing. Well, just remember, to shut everybody down?
No, well, remember, it's a 6-3 decision. So
right.
Yeah. So at least 3 justices thought there was enough there. 3 justices said, hey, free speech violation. We don't care so much about standing. The other 6, it sounds like the other 6, especially the 3 conservatives, really did not want to decide. I know they're a little more to the law and the letter of the law, I think those 3, but they did not want to decide this. They said you have no standing, because how were you hurt by that? How are these states hurt by this social media ban or encouragement? They're really not. That's why there was no standing. That's why they couldn't hear the case. And I think the court was very happy to, as they say, punt it. Let someone else bring it one day, years down the road, who has standing. Maybe somebody who their opinions were shut down. They might have standing. But a state in itself doesn't, in my opinion, have standing, or in the majority didn't have standing. So we had this interesting set of facts and no answer, no decision on the case.
Well, let me ask you this, and this is not, and on your please jump in. So, people are always asking me, and I worked in a media company for almost 20 years. It was, we had TV channels, we had newspapers, we had websites, blah blah blah. We were the biggest news information company in America in our day. But people would always say, and a lot of things would be like, so, one of my brands was USA Today, and USA Today, their editorial posture was, because we were competing against the Wall Street Journal, which embraced the idea of conservatism, the voice of conservatism in America, blah blah blah. The other side was the New York Times, which embraced the idea of where you live, David, New York, liberalism. Okay, USA Today was like, we're not going to be you guys. We're going to carve out our own market position. We're going to try to be objective as much as we can, which I don't know. How much can you be? Because everybody I knew in the newsroom was a Republican. But as part of their job, they were like, okay, well, we'll try to be objective. But here's the thing. When you look at something like the Fox television network and the MSNBC.
Yeah.
Yes. Okay. Fox wears their conservatism on their sleeve.
Yeah.
MSNBC wears their, and nobody says, hey, and the thing is, they're like, hey, First Amendment, man, I can, if I hate Obama and Clinton and Biden, I can say whatever the hell I want. And then MSNBC is like, if I hate Trump and Vance, I can say whatever the hell I want. Right? So, and nobody, and these guys have been around for decades and decades. Nobody says to them, no, stop being conservative. Stop being the voice for every crazy right-wing person. No one says to MSNBC, stop being the voice for every left-wing crazy person. And they're on TV 24/7, 365. And when's the last time anybody dragged them into a Senate hearing?
No, but remember, Fox News last year got dragged into court for defamation? What was it?
Well, right.
Oh yeah, that whole thing.
For the there is a concept of slander, right?
Yeah.
And they lied about the software used in polling.
Yeah.
And the thing is, like, I used to have to, as part of my job, I would listen to all the companies would have quarterly conference calls with shareholders and media, and then I would like write up stuff. And Fox was always very, very careful in that they were always like, you know what, we're just doing opiniontainment. We're not telling you anything. But in that particular case, the Horizon software, blah, 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 it was an opinion. They said, hey, these guys, we're telling you, we have facts. These guys actually screw the election, which turned out not to be true.
Huge distinction there. Absolutely. You can give your opinion.
Right.
But once you actually go beyond that and you're actually spreading falsehoods that aren't opinions, but they're presented as facts, that's a very big difference.
Well, in these social media companies, whether it's Facebook, Twitter, it's people like me and you and Anurada that are posting things on there. The company calls itself a technology solution. We're not we don't publish media. Our people do. And if I want to put up a post that has Barack Obama hanging from a tree, hey, it's not us. Look, that asshole is doing whatever he wants. Look, he's got his First Amendment rights. So, we're like the telephone company. That's what they always say. We're like we don't, tell people what to say on a telephone. We're just, you guys, we're not a media company like USA Today or the New York Times or the Wall Street Journal, where there's like an editor and an editorial guy. They decide what gets into the paper, whether it's an actual paper or online or whatever.
No, it gets tricky.
Is that a difference?
That's the problem. Yeah, that's the problem here. You're right.
Okay.
How do you draw the line? You're right. It's very easy if it's just a newspaper or media out, but now you're talking about social media companies who are not actually printing these things. But, they have some responsibility to some extent. Like, look, First Amendment, as we all know, is not absolute, right? As they say, you can't yell fire in a movie theater and say,
right.
First
That's
Amendment.
The thing that always comes up, yeah.
I can't tell someone, hey, go kill Thad, and say, just First Amendment. You can't do that. So,
darn it! I would just love to be killed. I mean, if you could just do that, get that one through. But go ahead, right?
The First Amendment, So the First Amendment has its restrictions. And I think that's where it gets tricky. And can you restrict someone else's? And remember, the First Amendment has to do with government and the people, not in private industry. Right? So technically, I could have an employee. An employee can't walk in here and say, screw you, Grover, I hate your guts, And if I fire them, they can say, no, First Amendment. Can't do that. It's private industry. I can fire somebody for what they say. I'm not the government. So that's kind of the difference.
Is that why so many people leave your firm?
Very few.
Come on. Hey, audience, I'm joking. He's a 4-year super lawyer.
We actually have
everybody know. People are like waiting in line outside his door to get a job.
We have people here for a lot long, many, many, many years. When our senior person here, about 15 years, actually. Yeah.
Oh,
been a while.
Wow.
Yeah.
That's cool.
No one wants to be in a car or a motorcycle accident or a slip and fall that causes physical or mental damage, and even construction accidents are on the rise today. But if you or a friend or family member are injured, you need a professional and understanding law firm that has experience in getting the most for their clients' injuries. And you can find all of that at the law firm of Grover and Fensterstock. They are a premier personal injury firm located in New York City, and their track record is excellent. They have years of experience working and winning for their clients. Now, they offer a free consultation, and they only get paid when you get paid. So how do you get in touch with them? Well, you call David Grover at 1-866-99-LAWYER and mention that you were referred by the Scandal Sheet podcast, one of your favorite podcasts, of course. So David Grover at Grover and Fensterstock, 1-866-99-LAWYER 866-99-LAWYER. You'll be glad you called.
I'll be your janitor if you need one. Yeah.
That actually applied like 10 times and he's throwing his application away. Come on, David.
I have big files everywhere. Can you need help cleaning up sometimes? But, you know. It's,
So, Anuradha, what do you think? What do you think about all this mess?
I mean, listen, I'm pretty sure those old fogies with the little wigs that were sitting around creating these things didn't think they would need to like spell things out. But in this day and age, you know, where you can basically poke a bunch of caveats and holes into things, you know, it probably needs revisiting. You know, we got to spell some things out for the Orange Man and a bunch of other people out there that want to, you know, swim through the gaps and do whatever they want to do. You know what I mean? I think this needs revisiting. Who's going to do it? I don't know. But at the same time, should we keep relying on something that was created, you know, hundreds of years ago by, you know, a bunch of old fogies? Probably not. You know, that's my thought, you know. Scandalous.
It's scary. You know, it is. But it's, and look, I mean, that's a whole other episode. We can get into constitutional interpretation and what it means, and should it be nuanced over the years, or should it be just what they discussed at the Constitutional Convention? You know, there are so many theories of law about how to interpret the Constitution. So what you said is not really crazy. It's just one of the many interpretations of the Constitution, and different judges and different legal minds have different thoughts on that. So it's really a very tricky subject matter.
Bernice, what's next?
Case 23-222, Alexander versus South Carolina State Conference of the NAACP. After the 2020 census, South Carolina's Republican-controlled legislature adopted a new congressional map that moved tens of thousands of black voters to a different district, effectively making the district a safe seat for Republicans. The South Carolina State Conference of the NAACP sued, and a three-judge panel concluded that the district was an unconstitutional racial gerrymander. The legislators appealed directly to the Supreme Court, arguing that the map was actually a political gerrymander, which is permissible, that merely had a racial effect. Question: does the South Carolina legislature's redistricting map constitute an impermissible racial gerrymander?
David, another 6-3 decision.
Yeah, this was also actually very interesting, and in some respects, at least on the surface, very contradicting to some of the prior cases on this, right? So the question really comes down to, we all know what gerrymandering is, drawing up congressional districts to suit the party in power typically. Now, the court came down about a year or two ago, I think on this podcast we discussed it, that you can't have racial gerrymandering. You can't make congressional districts based on race. The court said absolutely not. So here, this case, the court said, okay, it's okay because it's partisan gerrymandering.
Which is okay, right? Under the law.
It's bizarre. Yeah, that is okay under the law. But it's just the funny part about this case is, well, which one is it, right? Because it's done racially, but it's also done for party purposes. So the court essentially decided in this case that there wasn't really evidence presented before, and I think they did remand some things back to the trial court, but there wasn't enough evidence presented that it was done for racial reasons. More so, it looked like it was done for partisan reasons. Look, I mean, it could have been done for both, but it was, in this case, it looked, at least the majority said, no, this is partisan gerrymandering that happened to have racial overtones. As opposed to
how do you separate those things? I mean, because, all of us know, certainly, Anuradha knows that, okay, the Republicans are just going to be crawling up my ass every fucking day of my life. But, and every black person and anybody of non-Caucasian is like, okay, these guys are going to kick my ass forever. So, very few people. I mean, if you give them $1 million, maybe they'll stand up and talk for 5 minutes about Trump at his rally. But, and then they'll walk out the door and say, that motherfucker. But sorry. But, I mean, how do you separate it, David? How do you mean, partisan versus racial bigotry?
And that's the tough call. And I think that's somewhat what the dissent was trying to say here. So how do you do that? I don't know. It's a factual determination. Someone has to decide factually what was their intent, right? Was your intent? Because a lot of times it might be both. So what was the intent here? Was it more partisan? Was it more racial? But I don't know how you could sometimes separate the two, because it's really intertwined, at least in today's society, the way our parties are separated, that you're kind of doing both. So the reason this is tricky is now the courts have to decide, what do they think? Is there enough evidence to show something is racial as opposed to partisan? And let's face it, it's not the kind of thing where people are going to come out and say it, right? Politicians aren't going to come out in a hearing and say, we want less black people in this district. No one's going to say that. So how do you determine that? Well, that's your guess is as good as mine. Now, this didn't, not get too technical here, but there were different laws involved here. The old case with Alabama was the Voting Rights Act. This is the Equal Protection Clause. So it involved a few different nuances to it. But yeah, at the end of the day is, how do we figure that out? I don't know. I don't think anybody knows the answer to that question. So it's really going to be almost on a case-by-case basis.
Well, didn't this come with, and don't have the exact site, but didn't a big chunk of the Voting Rights Act of 1965-66 get struck down years ago, and that opened the door for a lot of this stuff?
Yeah, it did. So that's why the presumption, that's why this case, again, they were able to logically put an argument together for it.
Okay.
So if you believe the court's determination that this was a partisan gerrymandering, then under the previous cases that, again, the Voting Rights Act was changed, then it makes sense. Then they are actually correct technically. So it's really, to me, it just comes down to whether or not you believe it was partisan or racial, and who knows the answer.
Anurata, what do you say?
I feel like things are just really not spelled out correctly. Like, everything is just so subjective, right? Depending on who you talk to, right? Like, one person say, oh, this is partisan. Someone say, oh, this is, racial. What are you gonna do? Who's gonna finally make that decision, right? More people who have their own subjects, that kind of thing.
Sometimes law, you could almost make a good argument for anything. You could almost, in a lot of cases, not every case, you could almost say, this is the result I want to come up with, and then go back and make the argument to reach that result. Because there's always cases to back you up. There's always a logic you could come up with. So yeah, that's the good or bad or issues we have with our case law, with our court system. And you hope that most of the time our judges, our courts make the right decision.
Well, what's the blowback on this? Does that mean, because there are blue states that gerrymander too, to their benefit, right? Maybe not as many as there are GOP states, but everybody's doing it. Everybody's doing it.
They'll do it. They'll do it. They have to do it. Okay. I think every state has done it. State courts sometimes have their own courts that throw out gerrymandering. There's been state court decisions on these things as well. But they all do it. But I guess when they do it now, you said blowback, they really have to be very clear that it's partisan and not racial, because racial is a no-no, and partisans at least with this Supreme Court, is okay.
Okay, so let's talk about ethics in the court. At the top of this episode, we played an excerpt of one of your New York Congress people, David, entering articles of impeachment against Justices Alito and Thomas. Now, David, I asked you about the potential of an impeachment of a Supreme Court judge last year, and here is what you said. But Congress does have an oversight responsibility for the administration and the other branches. Isn't that written into the Constitution?
There's not really. There's not much they could do. There's only really two things that they could ever do to the Supreme Court. Well, forget impeachment. That never happens. That's not going to happen.
So David, what happened? The Republicans still have a razor-thin majority in the House, so the motions won't pass this year. But if the Democrats win back the House in November, she's sure to bring it back.
Yeah, I think so, and it remains to be seen as to whether there's enough to bring it to the floor, because you never know. Even if the Democrats control the House, they may not want to rock the boat. You don't know what the political environment's going to be back then. In those days, it might depend on what decisions come out in the next term. It's hard to predict the future. But sure, I mean, she could put articles of impeachment in for them. They could have hearings. I wouldn't be shocked if there were hearings involved. And, who knows if it would get through the House. Now, I would assume there's zero chance of conviction in the Senate. You still need 2/3 of the Senate.
2/3.
To convict.
Yeah, no one's getting that. Yeah.
No, I mean, you can't get 2/3 of the Senate to agree on anything, So.
No.
The odds of that happening are very, very small. But, having hearings would definitely make things interesting. Things might come out, evidence, testimony. Would they testify themselves? Probably not. But they would have other people testify. And then, who knows where that leads. Probably not a conviction, but it would definitely be a very, very big and a controversial set of hearings.
So even if she can't win in the Senate, the spectacle of two Supreme Court justice televised trials in the Senate and all their lifelong dirty laundry displayed for the entire world might cause them to resign instead, right? I mean, Thomas is 76, Alito is 74. Retirement is clearly not out of the question for them yet. And maybe something they're thinking about anyway?
Well, a couple things on that. Now, I don't know either one of them personally, but they don't seem like the kind of people that would ever resign. I mean, they are trying to think of the right word, but they are not a run away and hide type of justice. So I think they're very strong in their beliefs, and the odds of them resigning, I think, are next to nothing. However,
so they're going to work till they die, like Ginsburg,
ride or die.
I don't know but I also think they believe in their beliefs to such an extent that if, for example, a Republican is elected this coming November, and they're not so sure if the Republicans will be reelected after that, then they might step down.
Okay,
like Kennedy did. I can't imagine ever them stepping down if there's a Democrat in the White House.
Okay.
But they might step down if there's a Republican in the White House, so they could be replaced by somebody of their liking.
So can we talk briefly about Supreme Court reform? Now, after being very reluctant to express any opinion on the court for most of its time, the Biden administration, now that they're out of the campaign race, now they have nothing to lose. Biden is a lame duck. So the handcuffs are off. And he recently announced, only a few days ago, a number of reforms right out of the White House itself.
Yeah, so, President Biden set forth really a set of reforms for the Supreme Court, unlike really anything we've seen. So he asked for basically three things. He's proposing three things. An 18-year term limit for each justice as opposed to the lifetime appointment.
Woo!
An enforceable code of ethics, and then a constitutional amendment to counteract the Supreme Court's presidential immunity decision. So,
That's big stuff. I mean, that's historic stuff.
It is. But, just politically, I would imagine 1 in 3 would be pretty tough to get through. The third one, a constitutional amendment, to me, that's something that almost like you brought up the impeachment. It's more to get the word out there, to make a statement than to actually make it happen, because you can't get a constitutional amendment is almost impossible to get through. So the odds of that actually happening are very small. Perhaps they could start the process to get this out there, but I can't imagine a scenario where that would actually occur. Remember, everybody makes these decisions on how it affects their party. So, for example, the first thing, the 18-year term limits, are something that parties are going to agree or disagree depending if it helps them. I think if you ask random people, they might agree, okay, this should be a term limit, why not? And I think the way it was going to be set up, if I'm not mistaken, is a Supreme Court justice would be nominated, available every 2 years. So, right? So in theory, every president would get to nominate 2 Supreme Court justices. And I think one of the points of having that would be so justices, like I mentioned earlier about Alito and Thomas, wouldn't be able to coordinate their retirement plans with a person of their party in power. So they would actually, every 2 years, no matter who the next president is, they get to choose a Supreme Court justice. So it's interesting. Can it happen? It might be tough. Things like that don't happen unless both parties think it's in their best interest for that to happen. I think something that is much more likely to happen is the code of ethics. I mean, everybody kind of nobody is very few people out there on either side are cheering when justices receive gifts from billionaires. I don't think that's something that most people love. So things like that. Remember, and a lot of these, in this code of ethics, in most states in the federal judiciary, they are applicable. You can't do that. I can't go to court and give gifts to the judge for my case. You can't do that. A judge is supposed to recuse himself if a friend, colleague, someone you do work with is before the court. You're not supposed to do that. So things that...
But they do. But these guys do.
Just them, because they don't have an enforceable code of ethics that applies to them.
That the rest of the federal judiciary does.
They have certain things they have to do.
So 9 people out of 1,000 get out of jail free card in the vernacular of the Monopoly board game.
Yeah, so I think I quoted this last year on one of the prior podcasts from Greece. The rules are there ain't no rules, right? I think it was Craterface said that to John Travolta. No rules. So
wow. Okay. Craterface and John Travolta kind of looked that up. Okay.
So they could do it. So they and really they don't want, the Supreme Court doesn't want anybody giving them rules. Mm-hmm. And again, like we discussed earlier, there's always reasons and logic behind every all these things people say. The logic here by their standpoint is separation of powers. Congress should not be, or a president should not be telling the judiciary what to do. So they're basically saying their argument is going to be, no, you don't get to do that. You're not the judiciary. And of course, then there's a whole bunch of other arguments that, this should be a code and this is why. And sometimes, you can't checks and balances. There's a whole slew of arguments for and against having a code of ethics. But that's probably the one item that has the best chance of being implemented one day.
But let me ask you this. So back in the 30s and 40s, the Supreme Court at the time, which had been appointed by Republican presidents, but it was FDR's term, and he was doing the New Deal, and these were more socially conscious, left-leaning policies because it was in the middle of the Depression, right? And these old guys were not helping him at all, and they kept striking stuff down. And he said, okay. So he proposed all of these reforms to the Supreme Court, like he was going to add judges and stuff like that and change the mix. And just by doing, now those things didn't go through, but just by doing that, what happened? All of a sudden, hey, you know what? We changed our minds. Social Security's okay.
Yeah. Yeah.
The Workers' Progress Act is okay. You know, I don't know what we were thinking. I guess we were drunk, but it's okay now. So, do you think by impeaching, the FTARs, I'm sorry, the justices, Alito and Thomas and some of these other things will scare them into not being fascist anymore? Or not as much?
My guess is not those two. We live in a very different society, definitely a polarized, partisan society. It's not quite it was back in the Great Depression, back in the 30s, 20s and 30s. So I don't think so. Yes, does Justice Roberts care about these things? I think he does. He cares about the court's reputation and the court's history. Perhaps Barrett, perhaps Kavanaugh. I think Thomas is a different individual. Alito, I don't think they'd rather a good fight than having a nice consensus. So that's my opinion, and you could tell from what their decisions, and even when you have these conservative decisions, you have people like Thomas and Alito writing concurring opinions because they want to go further than the Roberts of the world, the Roberts court. Because Roberts, again, I think he is pragmatic and cares about history, cares about his reputation. So yeah, I don't see them, but I think someone like a Roberts would be affected by certainly public opinion.
So, Honorata, what do you think? I was going to ask you guys if we were able to fire everybody and appoint 9 new people, who would they be? I was going to say, Taylor Swift was just Person of the Year, Time Magazine's Person of the Year. Now, why she would accept a $200,000 job, I don't know. She makes that in a week, right? So that probably wouldn't do it. But, who would you guys appoint? If we fired everybody, just said, look, we're done with you guys. I don't know how we could do it constitutionally, but let's say we could. Hypothetically, in fantasy, we're clean slate. David is the president. Kamala Harris is the president. No, Anurad is the president. David's the vice president. Woo! So
I wasn't born here, so we're going to change that rule too.
Okay. So we can't do that. So, but David, who are you appointing? Who are you sending downtown?
It's funny. I think, and this is unfortunately not a very fun, sexy answer, but
okay.
A lot of our former presidents in the pre-partisan era.
Was there a pre-partisan era? You mean Washington?
Less partisan era.
Okay, less partisan.
Where the Bushes and Clintons and Obamas would hang out and have dinner together and do.
No, they're all pretty friendly and they go to each other's funerals and they just kiss and hug all the time. And we're like, what the hell? Why can we have people like this now?
Oh,
there's no way Trump is kissing Biden.
No, it's a very different. It's funny. I was in Atlanta this week, and
during the Trump rally.
No, I was gone right before that. And also,
after the Harris rally?
Yeah, I was there, I think the day after. I was there around that time, but it wasn't the exact day. So
was it a big deal?
No, not really when I was there. Not the day I was there. So what I did was I stopped off at because I've never been to a presidential library. Or maybe when I was a kid, I went to FDR from when I was very little. So I drove over to the Jimmy Carter Presidential Center.
Oh, wow. I forgot he was from Georgia. Yeah.
Yeah, and that's where he has his center. And I'm just, just as a political junkie, I just wanted to see any presidential library. It wasn't for him in particular. I would have went to anyone. So I went to it, and they had a debate on the Carter-Ford debate. It was actually a bad debate for Ford. If you remember, Ford said there was no Soviet domination of Eastern Europe, may have cost him the election. But the part that stood out for me was the part when Jimmy Carter, Ford said something, and then Jimmy Carter said, Gerald Ford, he's a good and decent man. We have policy differences. I'm like, wow, could you imagine anybody saying that today in a presidential debate? I mean, it was shocking seeing this. And that's unfortunate. We don't have that anymore, in my opinion. But yeah, so my back to your original question was, if you had, I mean, George H.W. Bush is deceased, but George H.W. Bush, George Bush, Clinton, Obama, people like that, they might have a nice consensus on a Supreme Court. They might be able to help our country, in my humble opinion.
Well, I mean, Clinton and Obama, I mean, they have great law degrees. They would be legitimate candidates, theoretically.
And yeah, you don't necessarily have to be an attorney. You have people work for you.
No, and that's the argument. Is like, how come all these guys, even though, they're like, oh, look, we've got a black person and a Latina person, they still come from either Harvard, Yale, or Princeton. They're still coming out of the same factory, right? It's still, I am an iPhone. I'm not that different. I am socialized with the rich people. Anyways.
But that brings a really good point, though. Like, why have things become so borderline verbally abusive, right? And it's just like, why should we trust you now? You know what I mean? Like, I know there was so much mudslinging and so much crap going on between Nikki Haley and Trump. And now all of a sudden, she's like, oh yeah, he's a great guy. Why should I believe you? Like, you know what I mean? And like, vice versa, if she would just somehow run, the crap he said about her. You know what I mean? Like, it's just like, the mudslinging has come so far, and then they're going to turn around and be like, oh yeah, vote for this person, I vouch for this person. Like, why should I believe you? You know what I mean? And like, what is your credibility? So I just feel like back in the day when things were a little bit more classy, you know what I mean? And it's just like, we've just come so far from that. It's just crazy.
No, there's no civility. Yeah.
Mm-hmm.
Nah.
Well, it's time to gavel out on this episode, folks. I want to thank our esteemed guest, David Grover, 4-time Super Lawyer Award recipient in the New York City area, for his great insights on the just concluded Supreme Court term. David's unique ability is to couch everything in terms even a normal human can understand, which is rare for a lawyer. Now, we know you've heard his commercial, but you probably didn't have a pen and paper with you in the car or the gym. That's why we put his contact information in the liner notes of this episode. So go in there and click on whatever you want. We hope you'll follow or subscribe to Scandal Sheep on your favorite pod platform and share it with all your friends. We'd also love it if you'd leave us a shameless, over-the-top rave review on Apple Podcasts especially. That helps us build audience. Also, we want to hear from you! You can reach us by email at scandalsheeppod@gmail.com, on Facebook, X, formerly Twitter, TikTok, LinkedIn, and just about everything else out there. We'll see you next time on Scandal Sheet!
Copyright 2024. Thad Halsley Media, LLC. All rights reserved.